Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. And starting today, we're going to be posting bi-weekly videos to keep you up to date with all the changes happening in U.S. immigration laws. If you want to be updated and alerted anytime we post a new video, please make sure to hit the like and subscribe button below this video. Now let's talk about the 4 biggest changes to U.S. immigration laws just in the last 2 to 3 weeks. These changes include changes to the U visa application process, the treatment of Iranian foreign nationals, the public charge rule, and also the addition of 5 countries to the existing travel ban countries. The first major change involves changes to the U visa application process. The U visa application is designed to help foreign nationals that are victims of crimes involving substantial physical or mental abuse. The U visa application allows the foreign nationals to come forward, help local law enforcement investigate the crimes, and they are promised that they're not going to be placed in removal or deportation proceedings if they are helpful to the investigation. On December 30th, USCIS published an alert regarding the U visa application, and the alert reads, "We may reject your Form I-918 if you leave a field blank, unless the field is optional. Optional fields includes a safe mailing address, as well as fields you should only complete if you answered yes to a previous question. You must provide a response to all other questions, even if the response is none, unknown, or not applicable. We will reject a Form 918 that has, for example, an empty field for a middle name, for current immigration status, or for information pertaining to a spouse or child." Now let me explain why I am so upset, why I'm so frustrated with these new laws. These new laws hurt crime victims, not just any foreign national. They are hurting victims of crimes that involve substantial physical or mental abuse. You have to understand that these crimes involve kidnapping, murder, rape. These are the kind of crimes that these victims have encountered. And now these victims are sticking out their necks to help local law enforcement investigate these crimes, and yet the government is making it very hard for them to stay protected and not risk being placed in removal or deportation proceedings. What the government is doing now is making it they're being very nitpicky in rejecting or denying these applications. Let's say, for example, back in the past, a person applies for a U visa application and that foreign national does not have a middle name. So that person would fill out the application. In the section where it involves a middle name, they would just leave it blank. The foreign national would submit their birth certificates, their passports, other forms of ID to show they've never had a middle name. The government will accept the U visa application, look through the application, notice that the middle name is missing, and then notice that the person doesn't have a middle name listed on the birth certificate or passport or other IDs, and will assume that the person has no middle name, and the application will move forward. Now, with the most recent changes on December 30th, if a person has no middle name, they leave the middle name spot blank, even though they submit their birth certificates, their IDs to show that they have no middle name, the government is still going to reject and deny that application and make it harder for that U visa applicant to apply for benefits. And this is why the changes to the U visa application procedures is making America less safe overall. If foreign nationals are afraid to come forward with information that could be helpful to a crime investigation, it makes Americans less safe. Now we will have more criminals running around just because the government is making it so difficult for these crime victims to want to come forward and provide useful information to an investigation. The second major change to U.S. immigration laws involves foreign nationals from Iran. Now, Iran has always been on the list of travel ban countries, meaning that it's very hard to get visas to come to the United States. However, before, if you were applying for an F1 student visa, an M1 vocational or technical school visa, or a J1 cultural exchange visitor visa, you can easily obtain these visas because they were exempt from the travel ban for Iran. However, now, we are getting reports that F1 students, M1 students, and also J1 cultural exchange visitors are finding it difficult to obtain visas to enter the country. They're getting their visas denied, and some people with an existing visa are having them revoked.
His attorney, 27-year-old Ali Reza Yazdani Esfidajani, hoped to continue graduate studies in agriculture at MSU. But his attorney, Ghazal Marani, says he was detained by Customs and Border Protection on Sunday after flying into Detroit Metro on a student visa.
To make matters worse, on January 29th, the U.S. government announced that Iranians are no longer eligible for the E-1 or E-2 visas to enter the United States. Now, the E-1 treaty trader and the E-2 treaty investor visas allow foreign nationals to come into the U.S. and start a business, work for that business, and it requires that these foreign nationals hire U.S. workers. Now, with the new ban in place, people that are trying to apply for a visa to enter for the first time are being denied. Also, people that are currently inside the United States with an E-1 or E-2 visa are now being told they cannot apply for extensions. So what these people will have to do now is close down shop, fire their US workers, and leave the country. And this not only hurts Iranian foreign nationals, it hurts the American public that are employed by these foreign nationals. Now, if you think it can't get any worse for people that were previously Iranian foreign nationals, think again. So we have been receiving reports, and this is reported all over the United States, that people that are green card holders and US citizens that were previously from Iran are given secondary screenings at the airport when they're returning from a trip abroad. During these secondary screenings, they are being taken out of the line and they're being grilled on their political affiliation and their political opinions, and they're being asked to give the Customs and Border Patrol their cell phones and passwords to all their social media accounts. Now let's talk about the third major change to U.S. immigration laws, and that is the Supreme Court's decision on the public charge rule. On January 27, 2020, the United States Supreme Court allowed the Department of Homeland Security to implement the public charge rule nationwide except for Illinois.
The Supreme Court has lifted a nationwide injunction against a sweeping policy targeting low-income immigrants. In a 5-4 ruling, the court approved the Trump administration's so-called public charge rule.
The regulation was unveiled in August. It gives officials more power to deny visas and green card applications from immigrants who the government determined rely or could rely on certain public benefits.
The public charge rule will make it very difficult for foreign nationals to apply for visas or permanent residency inside the United States if they have ever used public benefits such as welfare or food stamps. The public charge rule is very important because it allows the U.S. government to refuse entry or permanent residency to any individual that they believe is likely at any time to become a public charge. A public charge is usually defined as a person who is or is likely to become primarily dependent on public cash assistance for income maintenance or institutionalized for long-term care at a government expense. Government agents can look at a variety of factors to determine whether or not a foreign national is likely to become a public charge. These factors include age, health, financial resources, family status, education and skills, affidavit of support, and other factors. Now, who is really impacted by the nationwide public charge rule? The people that are impacted by this new rule include a foreign national applying for a visa to enter the United States, a foreign national applying for a green card within the United States, green card holders that spend more than 180 days or 6 months outside the U.S. and seek to re-enter the U.S. after traveling abroad, lower income individuals or elderly individuals using government assistance, using cash assistance, or long-term institutionalization paid for by Medicaid. Medicaid recipients, food stamp recipients, Section 8 housing assistance recipients, subsidized housing recipients, cash assistant recipients such as Social Security income, TANF, and general assistance. Now that we know who is impacted by the new nationwide public charge rule, let's talk about who is not impacted by the new rule. A green card holder applying for naturalization or U.S. citizenship. A green card holder renewing their green card application. And this also applies to conditional green card holders too. Refugees, asylees that use or are using public benefits. Foreign nationals using health and nutrition programs or any non-cash assistance. Benefits used by any other family members. VAWA self-petitioners. U visa holders. special immigrant juvenile status holders, T non-immigrant status holders, and TPS applicants. The fourth major change to U.S. immigration laws involves the addition of 5 countries to the existing list of travel ban countries.
Here's your Channels TV Morning News update for February the 1st, 2020. U.S. President Donald Trump has imposed a new travel ban restricting immigration from Nigeria and 5 other countries in an expansion of his administration's policy blocking travel from certain nations. In line with the new policy, citizens from Nigeria, Eritrea, Myanmar, and Kyrgyzstan won't be allowed to apply for visas to immigrate to the U.S. According to the U.S. government, the policy was designed to tighten security for countries that don't comply with the U.S. minimum security standards or cooperate to prevent illegal immigration.
All of the travel ban countries happen to have one thing in common, and that is they contain a large population of practicing Muslims. On January 31st, 2020, the United States added 5 more countries to the list of existing travel ban countries. These countries include Nigeria, Eritrea, Sudan, Tanzania, Kyrgyzstan, and Myanmar. If you are a foreign national living in these countries, you will find it harder to obtain certain types of visas. Visitor visas, such as B1, B2 visas, are not going to be impacted. So if you want to come to the United States temporarily, it should not be difficult for you to continue to apply for these type of visas. Now, citizens of Nigeria, Eritrea, Kyrgyzstan, and Myanmar can no longer apply for visas leading to permanent residency or a green card. This means that if you are a U.S. citizen or green card holder and you're living in the U.S. and you have filed a petition for a spouse, a child, a relative, or a parent, or even a fiancé in one of these countries, they're going to find it much more difficult to obtain a visa to enter the United States. In addition to all of these changes, citizens of Sudan and Tanzania will no longer be eligible for diversity visas. And those are the top 4 changes to U.S. immigration laws just in the last 2 to 3 weeks. So if you want to be kept up to date with what's going on with U.S. immigration laws and policies, make sure to hit the like and subscribe button. That way you can always be alerted when we post new videos. Thank you again for watching Winning Law, and we hope that we have made immigration easy to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the Law Office of David Nguyen.